Good afternoon, ladies and gentlemen, and welcome to McGuire-Woods Securities Compliance and Disclosure Update. I'm Jill Webb, Senior Counsel in our Richmond office, and I'll be the moderator for today's presentations. For those of you who are less familiar with our firm, McGuire-Woods is a full-service law firm with more than 1,000 attorneys and 22 worldwide offices. Our securities experience covers all aspects of securities laws impacting public and private companies, as well as executive compensation. Before we begin today's program, I need to call your attention to the Q&A icon in the lower left-hand corner of your screen. You can use this to submit questions you may have for our panelists anytime during the program. We will do our best to address them in the time allotted, but if we don't get to them, we will be sure to follow up with you via email. You will also find a number of other resources along the bottom of your screen which you can explore during the presentation, including the meeting materials folder, where you will find a copy of today's slides as well as a link to a recent column authored by McGuire-Woods Securities and Capital Markets attorneys on the new SEC's rules encourage companies to go public. Without further ado, I will introduce our first two speakers with me here today in Richmond, Bryce Jewett and Daniel Howe. Bryce is a partner in the M&A, Corporate Transactions, and Technology Group and is based here in Richmond. He focuses his practice on mergers and acquisitions, corporate governance, and cross-border transactions. Daniel is an associate in the same group, and he's also based here in Richmond, and he focuses his practice on mergers and acquisitions, corporate governance, and cross-border transactions as well. Today, they will discuss the understanding of ACRN, which is Delaware's first MAE termination. Bryce and Daniel, go ahead.
Okay, thank you very much. It's ACORN, but we'll start with that. I'm going to start by admitting that for a long time as an M&A practitioner, I've struggled to explain or define the concept of material adverse effect with any kind of specificity, even when clients ask you without your adversary on the phone. I don't think I'm alone in that struggle, and we'll talk about some of the reasons why it's been difficult to define that concept. Prior to the ACORN decision, which was in the fall of 2018, I think M&A practitioners were stuck talking about material adverse effect somewhat loosely in terms of it being something that had to be core or essential to the transaction. I think we were comfortable saying that it was a higher standard than a lower case material or in all material respects. I think we were comfortable saying that it was something more than 5% of the transaction, but I think not many M&A practitioners were comfortable quantifying or giving any kind of objective criteria on what might constitute an MAE. And I think there are a couple of reasons for that. The first one is that the definition that's most often used in acquisition agreements, in my opinion, is entirely unhelpful. It essentially says that a material adverse effect is a material adverse effect. It's circular in nature, and there are some exceptions that are often negotiated, but the core of the definition is not helpful and circular. The second reason that I think there has not been a lot of specificity around this definition is that until the ACORN decision, the Delaware courts had never found that an MAE had occurred in the context of an acquisition agreement. There were a handful of cases that concluded that an MAE had not occurred. You might be familiar with the IBP Tyson's case in 2001. In 2008, there was Hexion versus Huntsman. Both were cases that concluded that MAEs had not occurred, and therefore buyers were forced to close acquisition agreements. And until now, a lot of the jurisprudence favored sellers and target companies in that debate. And ACORN now is going to enter that jurisprudence and providing buyers with something to point to. I don't think it's overruled IBP or Hexion in any way, but it's going to provide buyers with something to point to in this debate over when and how an MAE has occurred. And just as a quick aside, I'm going to use MAE, MAC, material adverse effects, all interchangeably. To me, they're frankly the same thing. A quick word about the merger agreement before I turn it over to Dan to give you the factual backdrop. The buyer was Fresenius. It was, at the time, a publicly listed German healthcare company. The target company was Acorn Inc., which was a NASDAQ-listed generic pharmaceutical company. In the spring of 2017, the buyer agreed via a merger agreement to acquire Acorn. The merger agreement is not the story here. It really is unremarkable in almost every way. It contemplated a two-step transaction, signing with a delayed closing. The representations and warranties, the covenants, and the conditions to closing were, pick your word, they were customary, they were normal, middle of the road. Two elements of the merger agreement that we're going to focus on here. The merger agreement contained both a backdoor MAE and a front door MAE. And when I refer to a backdoor MAE, I'm referring to the fact that the buyer's obligation to close the transaction was conditioned on the target company's reps being true and correct, except where the failure to be true would not reasonably be expected to have an MAE. That is a closing condition that is linked specifically to one or more of the reps and warranties. The standalone MAE, or what I call the front door MAE, is a simple condition that an MAE has not occurred between signing and closing, and it is entirely delinked from reps and warranties. We could do a whole program on the difference between the front door and the back door, but we won't do that today. So I'm going to turn it over to Dan to give you the pertinent facts of the case.
So the most important factual details really occurred after the merger agreement was signed. Beginning with the first quarter following the execution of the merger, Acorn saw significant year-over-year declines in its quarterly revenues, operating income, and earnings per share. Additionally, Acorn saw its EBITDA decline by 86% in the year following the execution of the merger. The merger agreement, as Bryce mentioned, contained typical covenants and reps and warranties and other provisions. One such provision was Acorn's obligation to operate its business in the ordinary course between signing and closing. Among other things, this obligation included investigating and remediating quality control issues, data integrity violations, as such issues or violations were identified. Despite having this obligation, following signing, Acorn decided to fundamentally change its quality control and IT functions without the consent of Fresenius. Most notably, Acorn replaced certain regular internal audits with so-called verification audits that only assessed Acorn's progress addressing its previous audit findings and didn't actually go out and identify any new problems. Additionally, management also froze IT investment, which had the effect of reducing data integrity oversight and halted efforts to investigate and remediate quality control and data integrity investigations. The opinion from the Delaware Chancery Court, all of these changes appear to be driven by a desire by Acorn to avoid uncovering anything that would derail the pending merger. In addition to these operational changes, or rather, as a result of these operational changes, in late 2017 and early 2018, Fresenius started receiving multiple anonymous whistleblower letters. The letters allege flaws in Acorn's product development and quality control process. Upon receipt of these letters, Fresenius notified Acorn and decided it was going to conduct an investigation on its own into these matters. Fresenius was able to conduct an investigation because it relied on certain access rights that were afforded to Fresenius, which are typical to see in merger agreements between signing and closing. And Fresenius went ahead and engaged legal counsel and technical experts to assist it with this review. Fresenius's investigation uncovered serious quality control and data integrity issues, including the falsification of data submitted to the Food and Drug Administration, which is a massive deal for Acorn because Acorn is a FDA-regulated entity. Interestingly, Acorn decided not to conduct its own separate investigation into these whistleblower claims, again, out of the concerns that an investigation would uncover facts that would jeopardize the merger. This decision was absolutely contrary to standard practice for a regulated entity, and that's something that the court kind of noted as another one of the facts that really stood out in Acorn's decision-making. In light of all of these issues, finally, on April 22nd of 2018, Fresenius notified Acorn that it was going to terminate the merger agreement. Fresenius asserted that it had a right to terminate the merger agreement based on Acorn's breaches of its reps and warranties, including those related to regulatory compliance, and its covenants, including its obligation to continue to operate in its ordinary course of business. Fresenius further asserted that it was not obligated to close the transaction because Acorn had suffered a general MAE, which triggered a right to terminate the merger agreement on the initial outside date for closing. Shortly after receiving Fresenius' termination notice, Acorn initiated litigation.
And there, just to follow up on that, the failure of the reps and warranties to be true, or that's the backdoor MAE, gave right to a termination event. It's interesting that the front door MAE wasn't coupled with a termination event, but it gave the buyer the practical leverage to say, I'm not obligated to close, even though it didn't have an express termination right linked to it. Okay, so I'm going to pick it up there. The court found two MAEs, not just one, and the court really organized those findings around the back door and the front door MAE. So I'll talk about those in turn. The first MAE finding was in connection with the front door concept, or the standalone closing condition about the absence of a material adverse effect. And in this particular case, the court focused entirely on the financial performance. The court used language to the effect that the financial performance fell off of a cliff. You had revenue declines of 29 to 34%, operating income decreases between 29 and 105%, earnings per share decreases between 34 and 300%, and EBITDA declines of 86% over the course of the year. The court didn't say that any one particular of those metrics would constitute an MAE by itself. I mean, for example, I could make a very good argument that a 29% drop in revenue may not be an MAE. But when viewed in the aggregate with the sort of overwhelming decline, probably in earnings per share and EBITDA and operating income, the court found that these were sufficient from a materiality perspective to constitute an MAE. And they even relied on the language in IBP that the declines in performance had to be durationally significant. The IBP court concluded that the declines at issue there were more of a blip on the radar and temporary, whereas in Acorn they were more durationally significant. So jumping to the second MAE that was found in this case, or the backdoor MAE that was, and this time linked to a specific rep and warranty in the agreement. Here the court focused on the legal compliance rep. And I think it's important to remember that we're talking about a target company in the pharmaceutical industry. It's a highly regulated industry, regulated by the FDA, and the court was faced with significant breaches of the permitting and the compliance reps. So it's not just a breach of a rep, it's a breach of a rep that goes to the very fundamental nature and core of what the target company was doing. So as it relates to this aspect, the court found that there were pervasive data integrity and compliance problems, there were intentional manipulation of data submitted to the FDA, and the problems were systemic in nature. And when you added all that up, given the regulated nature of the target company and the significance of those breaches, the court concluded that an MAE had occurred. The court could have stopped there, but in analyzing the second MAE that they found, it's interesting that they looked at it from both a qualitative and a quantitative manner. So with respect to the qualitative manner, it was sufficient for the court that the MAA finding that the target company represented itself as an FDA-compliant business with compliant procedures, but was ultimately found to be a serial offender with a non-compliant culture. And then with respect to the quantitative standard, and I think this is one that practitioners are probably going to focus on, the court found that the non-compliance resulted in a 21% drop in the total equity value of the target company. And they found that that was significant enough to be a material adverse effect. We'll talk about some caveats and the lack of bright line tests around that finding. But later in the year, in December of 2018, the Delaware Supreme Court upheld the Chancery Court's decision from October. So I'm going to turn it back over to Dan to give you a couple of what we think are the key takeaways associated with this ruling.
So the Acorn opinion, and as Bryce mentioned, was subsequently affirmed by the Delaware Supreme Court, and so it now provides a very useful, albeit very lengthy, outline for analyzing MAA clauses and acquisition agreements. With that said, it's important to remember that even in finding an MAA, the Delaware court went out of its way to reemphasize that an MAA is a very high burden that will rarely be found. One takeaway that we thought was pretty interesting in the actual MAA provision in the Acorn agreement, the Acorn agreement contained a carve-out for general industry risks, but most importantly also included an exception that if Acorn was disproportionately affected by such risks, then it wasn't a general industry risk. Acorn tried to argue that its financial declines, which were based on competitors and a loss of a key contract, were a part of a more fulsome risk in their industry and decline in their industry. Unfortunately for Acorn, the court concluded that Acorn's competitors were not similarly affected, and so it wasn't a general industry risk. The opinion also gives some good guidance on analyzing whether a target's financial decline constitutes an MAE. And as Bryce noted, there's no real bright line test, but there were several different previous court cases that had addressed this in the past. In IBP v. Tyson's, the target faced a 64% year-over-year decline in its quarterly earnings, but the court ended up concluding that that was not an MAE because that had only occurred at a short-term temporary effect. In Hexion v. Huntsman, another Delaware case, a 7% decline in the target's EBITDA was not considered an MAE, probably because even though the company declined, it wasn't material enough to really be of significance. Acorn is unique in that the financial decline had the right mix of materiality and durational significance, where the quarterly declines were consistent and steady, and they were getting worse each quarter. And then over the course of the year, the EBITDA went down 86%, and the cost of remediation and the effect of the target's value ended up being over 20%. So Acorn really had a unique set of circumstances that got the court to find that the decline in financial performance was actually an MAE. The court also gave insight into how it views MAE clauses as risk allocation device. Generally speaking, the takeaway from the Acorn decision is that the buyer takes the industry risk and the seller takes the company-specific risks.
Just a couple of quick asides here. I don't think it's a coincidence that the two cases we've cited are from 2001 and 2008. In 2001, you've got the tech meltdown, and in 2008, you've got the beginnings of the financial recession. And I don't think it's a coincidence that those two cases of buyers trying to get out of deals are tested in 2001 and 2008. So that'll probably continue to be a trend. The other thing that I would note is we've talked a lot about the fact that an MAE has to be durationally significant. There's language in the opinion that the court acknowledges that durational significance might be different for a financial buyer than it is for a strategic buyer. In other words, here you had one strategic company buying another strategic company. The court recognized that perhaps a financial sponsor or private equity buyer, the durational significance of a target company's performance may be shorter for that type of a buyer. We've alluded to this throughout the presentation, but there are a couple of caveats that just we have to hammer home here. It's certainly clear that Acorn provides some guidance and probably for the first time some objective markers about what will actually constitute an MAE. But it's also clear that that 21% on decline in total equity value is not a bright line test. The court went so far as to say that no one should fixate on a particular percentage as establishing a bright line test. The second thing that I would say is the facts in this case were really extreme, and they were really, really bad. And I think that's what you get. That's why you get this decision. First of all, the financial performance was terrible. We've given you some of the gory details there. Secondly, you had a highly regulated company faced with a breach pertaining to its very ability to license and sell its products. And finally, you had a company that breached its interim conduct covenants in a very egregious way. I think we've all, as M&A practitioners, given the advice that the status quo and the ordinate course and running the business in the same way that you run it historically is how you should operate in the interim period, and that just frankly didn't happen here. So when you add all that up, I think the court was able for the first time to conclude that an MAE had occurred. I think finally the analysis is going to continue to be very highly fact-specific. Buyers are going to argue that their facts are like Acorn, and sellers are going to continue to point to IBP and Hexion. But I think for the first time in negotiations, buyers are not going to have to hear from target companies that the Delaware court has never found an MAE, which I think if you've ever done an MAE transaction, you've heard that argument, and it's quite frustrating to hear it. I've also made the argument, so I'm able to talk out of both sides of my mouth on that. But Acorn's going to enter the jurisprudence as one of the seminal cases about whether or not an MAE has occurred. I'll stop there. I think I'm out of time. We had a couple of other little nuggets here that are really unrelated to the core of the presentation, but as Dan mentioned, the opinion is 250 pages, and it really offers a lot of insight into the way the court analyzes acquisition agreements, what they think the intent of certain provisions are, and it's quite a useful outline in terms of the court's view on acquisition transactions. And so we just pulled out a few nuggets here that you can read later, and I'm not sure I would suggest reading the full 250 pages, but, so we'll stop there.
Great. Thank you, Bryce, and thank you, Daniel. Our next presenter this afternoon is David Wolpa, who's an associate in our Securities and Capital Markets Group in our Charlotte office. His experience includes representing public and private companies in offerings of securities and mergers and acquisitions transactions. He recently co-authored a column called New SEC Rules Encourage Companies to Go Public that I referenced earlier. And today, David's going to discuss the SEC's report on recent cybersecurity incidents. David?
Good afternoon, everyone. As I'm sure everyone's aware, cybersecurity incidents have continued to be a matter that gained attention from the media, in business, and in government. And of course, the SEC itself has put out several pieces on this itself. The Division of Corporation Finance issued guidance in 2011. The SEC commissioners hosted a roundtable in 2014. And in February of 2018, the full commission put out a statement giving its guidance on cybersecurity disclosures and other cybersecurity-related matters. In October of this year, the SEC issued an investigative report that was very interesting because it was about cybersecurity and internal control, but rather than warning companies about just the dangers of cybersecurity, this was a report on investigations that the SEC Division of Enforcement made into companies that had actually been the victims of cybersecurity incidents. And the SEC investigations here focused on whether these target companies had complied with the provisions of the Securities Exchange Act requiring companies to devise and maintain systems of internal accounting control. And just by way of background, both the Exchange Act and the Sarbanes-Oxley Act rules require companies to devise and maintain systems of internal control over financial reporting that are designed to provide reasonable assurance that transactions are executed in accordance with company management's authorization, that transactions are properly recorded, and that access to company assets is permitted only with management's express authorization. In these 9 fraudulent cases that were the subject of the SEC's investigation, company personnel had each received spoofed or compromised electronic messages, emails, that purported to either be from a company executive or from an outside vendor of the company. These spoofed or compromised emails caused the targeted company's personnel to ultimately wire large sums of money or pay invoices to accounts that were controlled by the perpetrators of these cyber frauds. The SEC, among other government entities, have identified these particular types of email frauds as becoming increasingly common and pervasive. The FBI reported last year that business email compromises have caused over $5 billion in losses since 2013, and 675 million of these were identified as occurring in 2017. Now, despite, or really because these companies were the victim of these frauds, the SEC initiated investigations into these 9 companies to consider whether they complied with the internal accounting control requirements of the securities laws. In so doing, in the report, the SEC quoted from the original Senate report back in the late 70s when the internal control requirements were first made part of the Exchange Act, stating that a fundamental aspect of management stewardship of a company is to provide shareholders with reasonable assurances that the business is adequately controlled. So you can see how the requirement that the company's assets be controlled and access to accounts be controlled does relate to cybersecurity, and that being a victim of a cybersecurity fraud, while being unfortunate in its own right, is also something that matters to shareholders and impacts their bottom line as well. Internal control issues have long been important for the Commission, but that was recently underlined just last week when on January 29 of this year, the Commission settled with 4 public companies that had each been accused of violating the securities laws by failing to maintain effective internal control over financial reporting. Each of the 4 companies in those cases agreed to cease and desist orders, and each paid a civil penalty to the SEC. However, in these particular cybersecurity cases, the SEC determined ultimately not to pursue enforcement actions. Instead, it decided to publish the report about which we're talking today to make issuers aware that cyber-related threats of spoofed or manipulated email exists and should be considered when devising and maintaining internal accounting controls. Taking a look at the schemes themselves, each of the 9 investigated companies here represented a wide range of industries. Each had substantial annual revenues, and each had securities that were listed for trading on a national securities exchange. So we're not really talking about small companies that might not have strong governance or strong internal controls. All of these companies were of the size and scope that probably they should have known better. The report, however, did not identify these companies by name, and each of these investigated companies lost at least $1 million as a result of these cyber frauds. 2 of the 9 companies lost more than $30 million, and of those 2, one of them lost $45 million due to 14 separate wire payments that were initiated at the request of a fake executive over the course of several weeks. So there were 2 types of fraud used in these spoofed emails. The first type could be classified as emails from fake executives. In these cases, there were emails from persons that were not affiliated with the company. They were fraudsters, but they were pretending to be company executives. The perpetrators would email personnel in the company's finance department using a spoofed email domain and an address that appeared to look like it was coming from a corporate executive, often the CEO. The spoofed email then would direct the respondents who were in the company's finance department to work with a purported outside attorney who would be identified in the email, and then that attorney would direct the company personnel to cause large wire transfers to be made to foreign bank accounts that were, of course, ultimately controlled by the perpetrators of the fraud. The SEC noted that these frauds that involve these spoofed executive emails are not technologically sophisticated. Typically, all you have to do is create an email address that kind of looked like the executive officer's actual email address, and then send it to a recipient who could cause the wire transfers to be made. There were common elements that the SEC noted that were present in all of these emails. The emails discussed alleged time-sensitive deals that needed to be completed within a matter of a few days. Secrecy was emphasized, and the deal was not supposed to be discussed with other company employees. The emails suggested or implied or even stated that there was some level of government oversight of the transaction. I think one of them even referenced the SEC being involved in some way. It was an SEC, regulated deal. The requested funds were all alleged to be necessary for a transaction occurring in a foreign country or a foreign acquisition, and directed the wire transfers be made to foreign banks and foreign beneficiaries. In each case, there were really very minimal details about the alleged transaction that were provided. And in all these cases, the purported transactions really would have been unusual for these companies, even those that did have foreign operations or subsidiaries. The other type of fraud that was perpetrated among these 9 companies were fake emails from actual vendors. In these cases, someone would impersonate a person at the company's actual vendors. So these types of frauds were a little bit more technologically sophisticated, since they involved actual intrusions into the email accounts of the company's actual foreign vendors. The perpetrators would then insert illegitimate requests for payment with wire information into emails for otherwise legitimate requests. Often these requests were related to actual goods or services that were rendered by the vendors. However, the invoices were faked, or even real invoices were doctored to include fraudulent account information. These types of cases really threw up fewer red flags. There were fewer means of instantly recognizing that these were illegitimate. To kind of underscore that point, some of the company victims only learned that the scam had occurred and that they'd been defrauded when the real vendors asked about outstanding unpaid invoices for the services that were actually rendered, and then the companies realized that they had made payment to someone other than the actual vendor. So the upshot of these frauds and the subsequent investigation by the Division of Enforcement is that internal controls over accounting must reasonably safeguard the company and ultimately investor assets from cyber-related fraud in order to be effective under the law. This investigative report thus reiterates and underlines the position of the SEC stated in its February 2018 cybersecurity guidance, which of course also discusses internal control over accounting, in addition to the disclosure-related issues. The Commission noted that these frauds were really not terribly sophisticated in the design or their use of technology. That is, while their schemes involved emails and technology, ultimately it was weaknesses in policies and procedures and human vulnerabilities that made the targeted company's internal controls ineffective. The report, in this connection, the report highlighted the critical role that training plays at companies in implementing its controls. The frauds here succeeded in part because the responsible personnel in the company's finance department did not understand the company's existing controls or did not identify indications in the emailed instructions that the emails lacked reliability. That is, if there was supposed to be dual authorization for a large wire transfer, that wasn't followed, or people just didn't realize that the instructions in the email they were getting were, ought to have raised concerns. Since falling victim to these frauds, each of the involved companies has since sought to enhance its payment authorization procedures and verification requirements for vendor information changes. So the takeaways from this investigative report are that really all public companies should reassess their internal accounting controls as a result of these cyber-related risks and make any changes and adjustments that are needed. Companies that don't do this may risk, of course, not only losing millions of dollars as a result of a fraud, but then also face the double whammy of liability under the securities laws for having inadequate and ineffective internal accounting controls. Thank you.
Great. Thanks so much, David. Next, we're hearing from Kendall Manning. And Kendall is an associate in the Securities and Capital Markets Group in our Charlotte office as well. Kendall focuses her practice on mergers and acquisitions, securities, and other corporate matters. Kendall?
Good afternoon, everybody. I am going to be discussing the SEC's adoption of a new rule regarding hedging disclosure requirements today. This rule was adopted in December of 2017. And in discussing the rule today, we're going to go through the requirements for compliance of the rule by looking through the text. We're also going to be discussing who is subject to the new rule 407I, and we're going to be discussing when companies need to comply with this new rule. Okay. So, as we can see, this new rule adds a section I to item 407, and this is discussing corporate governance. It's not an altogether new concept, as much of the disclosure that's required here is required already in item 402B regarding CD&A and the material information necessary to understand compensation policies and decisions. In there, this includes hedging policies and practices. This new rule, item 407I, is different, however, because it addresses employees as a whole. So here we can see that this covers employees, officers, directors, and any of their designees. The Commission doesn't define designee. Rather, it explains that this is a fact-specific inquiry and that that's ultimately a company decision based on that company's policies. However, the Commission does explain that its focus is on policies and practices. So it will be interesting to see how that plays out regarding what is considered a designee. But ultimately, the rule incorporates flexibility for the companies to decide that on their own. Point of clarification that the Commission did provide, however, deals with registered equity securities. Excuse me, I'm just going to get back. And as we can see here at the end of this first paragraph, the rule does not explain for just equity securities. Rather, it explains for registered equity securities. And the instructions define equity securities as they are defined in Section 3A11 of the Exchange Act, issued by the registrant, any parent or subsidiary of the registrant as well. The Commission explained that this is more consistent with the goals of the rule to add registrant here rather than keep it broad. Oh, no. Oops, sorry. Okay. The Commission also explained that this created a more fair picture to shareholders as it's a common policy and affects the alignment of interest when employees are able to purchase or are compensated with equity securities of subsidiaries and parents. All right. So another interesting aspect of the rule is the standard that is used to explain these policies and practices. This is a standard that doesn't appear elsewhere in Item 407 and really doesn't appear elsewhere in Regulation SK. It was also not in the proposed rule, which means that we did not have public commentary on the fair and accurate standard of practices or policies. And finally, as the rule explains in subcategory 1, it explains some of the categories that are included in hedging transactions, but it notes here that companies need to explain which of those categories are specifically permitted and which are specifically disallowed. Finally, the rule also requires that if a registrant does not have any practices, it needs to disclose that fact as well. All right, so where will all this information be placed? This new rule requires the information to be put in a few different spots. So item 7 of Schedule 14A needs to have this information. The Commission explains that it's needed in proxy statements, understandably, because the information for the purpose of shareholders, and they need this information in the election of directors and officers. In doing so, the Commission figures that shareholders should consider corporate governance policies when making those decisions. Additionally, correspondingly, if a company is filing an information statement on Schedule 14C to promote consistent corporate governance disclosure, the items mentioned in this new rule, item 407I, will also be required there. Finally, the rule amends Instruction 6 to 402B of Regulation SK, and the purpose of this is to limit duplicative disclosure. It does not eliminate Instruction 6 of Rule 402B. However, it gives companies more flexibility to include this information. So, for instance, they could include this information required in 407I outside of the CDNA, and then give a separate 402B disclosure in the CDNA. But companies could also incorporate this information required by 407I directly in the CDNA or by cross-reference. All right, so who is subject to the requirements of Rule 407I? Contrary to comments, the Commission decided to include all U.S. public companies, including emerging growth companies and smaller reporting companies, in requiring their compliance here. And as we saw earlier, all employees of the company need to be included here, including executives, officers, and designees. And when do we need to comply? So the compliance dates for these hedging disclosures for companies other than emerging growth companies and small reporting companies, compliance needs to begin in fiscal years beginning on or after July 1st of 2019, and for emerging growth companies and smaller reporting companies, fiscal years beginning on or after July 1st, 2020. So that gives them an extra year. All right. Thank you.
Great. Thank you so much, Kendall. Next up is Maria Rasmussen, who is a senior counsel in our Richmond office. Maria focuses her practice on executive compensation and employee benefit matters. She also has experience in advising public companies relating to the SEC's executive compensation proxy disclosure rules. Maria is going to discuss the update on the pay ratio rule disclosures. Maria?
Thank you, Jill. Good afternoon, everyone. We are in year 2 of the pay ratio rule disclosures. Last year, 2018, was the first year. And some of the things that people are concerned about right now are what to do with respect to identifying the median employee in year 2. As a refresher for those who don't deal in this area all the time, the pay ratio rule requires most public companies to disclose in its proxy the median of the annual total compensation of all of its employees other than the CEO, the annual total compensation of its CEO, and the ratio of the two amounts. So in year 2, to ease the burden, the SEC has actually said that with respect to identifying the median employee, companies may be able to use the same median employee that they used last year for up to 3 years, and this is referred to as the triennial determination, unless one or two things apply. One is that if there have been any changes to the employee population or the employee compensation arrangement that would require redetermination, then they would have to determine a new, or go through the analysis again with respect to who is the median employee. And when they refer to changes, they refer to significant changes, although that is undefined, and so it's, you have to use a bit of judgment. But the types of things that you would look at with respect to the employee population change or employee compensation arrangement change would be, have there been population changes in the ordinary course, or has the workforce basically remained the same? If you relied on the de minimis exception, have there been any changes in global demographics that would affect that particular decision? Have there been acquisitions and divestitures from the prior year where you have a huge shift in the number of employees? And then changes in pay programs with respect to the level of pay, either with respect to the higher employees above the median or people below the median, or with respect to the CEO. So I should mention at this point that most companies will probably try to rely in year 2 on the person that they've identified in year 1 if there haven't been significant changes. But there's no requirement that you can't run through the analysis if you want to do it again. I'm not sure people want to spend the extra time doing that, but it is true. The second item that you really need to look at is whether there have been changes to the original median employee's circumstances that would make it inappropriate to continue to use them. And they do make an exception that if the person is terminated, you can use an employee who's substantially similar, who has compensation. So what a lot of folks are asking now, if there have been no significant changes to our employee population or to our compensation arrangements or to the median employee circumstances, are there other reasons why you may want to make a change? And I'll back up for a minute to say that if you do, even if you do use the same employee as you used last year, you have to actually say, the FCC requires that you have to state affirmatively that the registrant reasonably believes that the use of the same median employee would not significantly affect its pay ratio disclosure, and describe the basis for that reasonable belief. But the next question is there a reason to supplement or change the disclosure? In most companies' circumstances, there probably isn't unless you're getting significant shareholder pushback or you've been a recipient of, a letter, not just a letter, but maybe a shareholder proposal. As a backdrop, the general investor reaction to the pay ratio disclosures was somewhat muted until very late in 2018. There had been expected to be sort of a firestorm of employee reaction and press reaction to the various ratios, and it didn't really pan out. I mean, the highest ratio was 5,900 to 1. The lowest one was 0, where the CEO had no compensation. And as you would expect, there were very high ratios in the consumer discretionary industries and in retail, where there's more reliance on part-time help and temporary help. And then in energy, financials, and utilities, there was a very low ratio. But in late 2018, there was a letter that was sent to by 48 signatories to all of the Fortune 500 companies from institutional investors requesting that more information regarding general workforce compensation practices be disclosed. Specifically, it came from a lot of the union groups, retirement plans, AFL-CIO, CalSTRS, CalPERS, and also the New York Controller signed it. The letter was asking for more robust disclosure about broad general workforce practices, and I don't think it represents a trend necessarily in what we are going to see immediately in future disclosures, but they were asking for really very detailed things like identification of the median employee's job function, breakdown of workforce by job function and business unit, geographic location of the median employee, country-level breakdown of their employee headcount, use of temporary seasonal employees, and the list goes on. And it could be quite burdensome to folks. But the letter seemed to suggest that what they really wanted is that the disclosure of the median employee's pay would provide a reference point for understanding the general workforce compensation programs and give investors more of a context in which the overall approach to human capital management is handled. The second item that happened in 2018 was that the Officer of the New York State Comptroller issued a press release stating that they had submitted shareholder proposals to several companies to incorporate considerations about their broader workforce, similar to the letter that was sent to Fortune 500 companies. The NYSC entered into agreements with several companies that would require them to re-examine the CEO and executive pay and adopt policies that take into account the compensation of the broader workforce. And there are examples of broader disclosures which include enhancements to the employee base pay, whether or not they pay minimum wage, pay considerations, and global workforce types of things. So the question that we get asked is, do we anticipate changes in the reporting practices? I would say that there's a possible trend that there may be some companies who will voluntarily disclose, but there are really broader implications for doing that, because I think, you don't want to put something in your proxy that you really haven't thoroughly vetted, and you just don't want to willy-nilly go into setting a precedent for yourself, not to mention the fact that if you file something, you really have to be able to adequately affirm that it's accurate. But I give an example here that CVS actually put in last year's proxy, where they talk about the philosophy of their performance management, and they talk not only about the executive suite compensation, but also about providing opportunities for professional growth, development, and offer affordable benefits and programs to the diverse needs of their practice. There are all kinds of different ways in which to do it. You can consider whether you want to include some broader statement in your CD&A, whether you want to include something outside the CD&A in terms of your corporate governance. Some people, Salesforce.com has added a whole new section on sustainability, equality, and philanthropy, where they talk about promoting equal pay and gender, eliminating gender disparity. I think that the issue is you're not required to do this, and unless you're getting strong institutional shareholder pressure to do it, and you have maybe perhaps a problem to address, that I don't know that I would recommend doing it, but it is something that's going to, I think, continue to emerge, and so it's something to think about if you have particular types of shareholders that are interested in this, and that may ultimately have some influence. I should state that it is not an issue at this point in time that any of the institutional advisory groups like ISS or GL consider in their voting practice. And that's it. Thank you.
Great. And those, you want to move the slide deck forward just a few. Those last two are discussed on the last two slides there. And thank you, Maria, and thanks to our whole panel who did some great presentations today. In closing, we'll give a reminder to everyone that if we did not address your question during the call, we are happy to follow up with you via email, and feel free to contact us with additional questions or comments in the interim using the information displayed on your screen. Please join us next month on March 12th, and on behalf of McGuire Woods, thank you all for joining us today.